First, I'd like to thank everyone here for the opportunity to speak this morning in support of HB 2723, introduced by Representative Abdel Nasser Rashid.
I'm sorry, could you introduce yourself?
This is my next line. My name is Richard Goldwasser. I grew up in Skokie and now live in Highland Park. I've practiced law in Chicago for 35 years. One of my first jobs was clerking for the appellate court judge, Don Rizzi, right here in this building. My legal career began in 1990. Shortly after I took the bar exam in July, Iraq invaded Kuwait, which was the start of what became known as the Gulf War. Within a week, I was in Israel where I clerked for the president of the Israeli Supreme Court. And each day I carried a gas mask to and from the courthouse. After a year in Israel, I returned to Chicago, intending to pay off my student loans and move to Israel. Life, however, had other plans. I met my wife, Deborah. We started a family, and I stayed. I did manage to pay off my student loans, something that at that time a young person could reasonably expect to do in short order, though that's a story for another hearing. Over the past 2 decades, my wife and I have raised our 2 daughters, Ilan and Ari, in Highland Park, and have been members of a conservative synagogue. During this time, I served 6 years on the national board of J Street, a pro-Israel, pro-peace organization, and until last fall, I chaired its Chicago chapter for a decade. I share this background because there is a persistent perception that Jews are of one mind on Israel, and that criticism of the Israeli government is inherently anti-Semitic. That is simply not the case. In fact, a poll conducted after the 2024 elections showed that 90% of Jewish Americans believe that someone can criticize the Israeli government and still be pro-Israel. And we're not talking about milquetoast criticism either. According to a Washington Post poll from last September, 61% of Jewish Americans believe Israel has committed war crimes against Palestinians in Gaza, and 39% believe Israel's actions constituted genocide. These criticisms are not fringe. They are located well within the mainstream of American Jewish opinion. Having laid out my pro-Israel bona fides, something that I confess I find somewhat distasteful but necessary in a climate where some voices are privileged over others, such as Yasmina Lara, who sits to my left, I turn to the substance of my testimony. In 1967, Israel launched a preemptive war against Egypt, commonly known as the Six-Day War. By its conclusion, Israel had defeated Egypt, Jordan, and Syria, and had occupied the Palestinian territories of the West Bank, East Jerusalem, and Gaza. From the outset, some observers recognized the profound dangers inherent in a prolonged military occupation, not only for the occupied, but for the occupier. Simply put, occupation corrupts. And we see that corruption today in the daily violence carried out by Israeli settlers against Palestinians, burning homes, displacing families, and in some cases, taking lives. This says nothing about Israel's actions in Gaza, which raises grave concerns and deserves a hearing in a different tribunal. For present purposes, I want to highlight a warning issued in 1967 by Yeshaya Leibowitz, an Israeli Orthodox Jewish public intellectual. He said, "A state ruling a hostile population of 1.5 to 2 million foreigners would necessarily become a secret police state with all that implies for education, free speech, and democratic institutions." Leibowitz understood that sustaining an occupation would require suppressing dissent. That people of conscience would inevitably organize and speak out, and that democratic institutions, including the judiciary, would come under strain. For those watching the events in Israel, his warning resonates powerfully today. Now consider a parallel closer to home. In 1966, black citizens in Claiborne County, Mississippi, presented local officials with a petition demanding racial justice, desegregation, fair employment, and equal access to public accommodations. When those demands were ignored, community members voted to boycott white-owned businesses. The boycott was effective. In response, business owners sued the NAACP and others, winning a substantial judgment. But the U.S. Supreme Court ultimately reversed that decision, and NAACP was claiming that political boycotts are protected under the First Amendment rights of free speech, assembly, and petition. The court emphasized that the practice of persons sharing common views, banding together to achieve a common end, is deeply embedded in the American political process. Indeed, boycotts have been central to American history, from the Boston Tea Party to the Montgomery bus boycott led by Dr. King. They are a foundational tool of democratic change. So how did I come to testify here today? For many years, I believed that Israel's occupation of the Palestinian people was immoral, not only because of its impact on Palestinians, but because it threatened Israeli democracy. I hoped that by ending the occupation, we would preserve that democracy. Over time, the occupation deepened, now encompassing over 6 million Palestinians living under Israeli military rule for nearly 6 decades. And I came to see another consequence, its corrosive effects reaching the United States. Leibowitz's warning now applies here. Today, more than 35 states punish Americans for engaging in political boycotts targeting Israel. Illinois, a blue state, my state, our state, was the first of them. This is deeply troubling. First and foremost, the anti-boycott law makes Illinois complicit in the occupation. It directs our pension system to punish any company whose collective conscience leads it to withhold commerce from Israel or the territories it controls, the legislative euphemism for occupied Palestinian territory, where millions live under military rule without political rights. The corporate decision to withhold one's commerce as a matter of conscience is precisely the kind of action the Supreme Court vindicated in Claiborne Hardware. Illinois has put itself on the wrong side of that principle and on the side of the occupier. And the harm radiates outward. The statute that forced Illinois to dump Unilever stock because Ben & Jerry's would not sell ice cream in the West Bank settlements is the model on which more than 35 other states have built their own anti-boycott regimes. Illinois went first. Illinois licensed the rest. This is the corrosive effect of the occupation washing up on American shores, and our state's name is on the door. Punishing the politically motivated boycotts, the tool the Supreme Court protected in Claiborne, is of a piece with the growing fascism in our country, using the state of Illinois' investment power to shield Israel from the cost of denying Palestinians their political rights, while punishing those engaged in boycotts violates the very First Amendment, the freedom of expression, the First Amendment was meant to protect, and this constitutes a double foul. I support HB 2723 because it seeks to correct this wrong. It reaffirms the fundamental American right to political expression and restores a vital tool of democratic participation. Thank you.
Thank you very much. Next.